raising on behalf of state. The first is not that the state, while these proceedings were pending in the High Court for appointing CBI for investigation, and proposal was mooted, my lord, with respect to appointment of those who were in the waiting list, which obviously could not have been done, but that was approved, but never implemented. One person was appointed not on the ground because suffering on with cancer and humanitarian
Like
ground.
Thomas Sen or something.
Yes,
right?
and the High Court upholds that.
On humanitarian grounds.
Yes, that's right. Rest, there is no appointment. But what High Court has done is at page 281 in the relief, they said that now how this order was passed, an unimplemented order, how it was passed.
But Mr. Dwivedi, look at the way this whole process has been done. Originally, NISA, NYSA, I presume it is NISA, appointed without a tender.
No, I'm not defending that.
Then that data fintech comes in place of NISA. The chairperson of the staff selection committee says, I don't know how they have come in. The OMR sheets are completely destroyed by the staff selection.
No, that's the second issue.
The mirror images
My
are
lord-
not there on the server anymore.
Yes.
People who are not on the panel are recruited. I mean, this is completely, it's a fraud.
No, I
No,
represent those
just
who
a
are
minute.
in the panel.
No, just a minute.
We were in the panel, we were appointed, we are substantive. And how did
Brother, let me
the High
not-
Court terminate, Milord? High Court is not the appointing authority to terminate people.
But my issue, let me complete my issue.
Yes,
This
let
is
me
different
complete.
issue.
Yes.
I'm not on the issue of how these people were appointed and whether CBI found 8,000 odd candidates whose name have been found. So that's one part of it, that on the base, because CBI finds 8,000, how do you set aside 23,000?
No.
All of them, Milord.
So the whole process
Process.
was replete.
No,
with,
but that's the
with
second
replete
issue.
with,
I'm on the first issue. I'm more on the first issue, Milord, on behalf of the state. And that is, if your lordship looks at page 281, this has nothing to do with that appointment.
Just 1 second, let's see.
At page 281, this is post-appointment based on that selection list. There were certain wait list. To accommodate the wait list, page 281, number 8 at the bottom. The High Court has directed, Lord, that CBI will undertake further investigation with regard to the persons involved in the state government approving creation of supernumerary post. To accommodate illegal appointments if necessary, CBI will undertake custodial interrogation if necessary. Now, this is a case of creation of supernumerary post for waitlisted candidates, which was never implemented, and only one person was appointed whose appointment is upheld by the High Court.
So why was supernumerary posts created? Once they found that these appointments were illegal, High Court decides,
No.
the government decides to
By
create.
that time, there was no order of illegality.
No, my lords,
When this order was passed, there was no finding of the High Court about illegality. More than this, the state government passed the order in May, and up till November, no person was appointed. Then somebody challenged a writ petition, a separate writ petition, where that order was stayed. And that is a separate petition which is still pending before the High Court. And in this matter, an unimplemented order, it's a question of criminality. Illegality is one part.
But ultimately, this is only a direction to the CBI to undertake the investigation.
my lords, may I just
Custodial
ask what
they will register an FIR. The whole cabinet is involved. So whole cabinet during election goes into the jail. It's another incident.
May I just add to what my learned friend is saying? These supernumerary posts, the object was that since there are these challenges pending to illegal appointments, let people at least in the waiting list, that was the thought, maybe right or
How
wrong.
could it be?
Supernumerary posts be occupied by them so that there is no vacuum. A detailed cabinet note is prepared on the matter and placed before the cabinet. Now, ultimately, my lords, what is the import of this is that anyone involved in the preparation of the cabinet note, right till the approval of the note by the cabinet, can be interrogated by the CBI because and why were supernumerary posts created and taken into custodial interrogation. The important thing is this was never the subject matter of the writ that your lordships are dealing with. The impugned order arises out of a writ petition which has nothing to do with supernumerary posts or a cabinet note. That's a separate writ petition in the Calcutta High Court pending before a single judge where that cabinet note has been stayed. That's a subject matter of a separate petition. Now, Sunday in a division bench dealing with the issue of the larger issue of criminality picks up the cabinet note and says that the CBI can look into anyone who prepared the note or how these supernumerary posts were created. Now, to look at how supernumerary posts were created, you will look at the cabinet
All
note,
right, we
then you
heard the
look at
other
the
side.
officers and the cabinet.
We got the point. We
Yes.
hear the other side.
In
of
this
it.
petition, there is no pleading at all about it.
No, but this is the wrong SLP. This petition was not heard.
Just, not in my matter.
Abhishek.
Your lordships, we were before your lordships in the first round. Your lordship sent us back to the High Court. The High Court says, I will not hear you. Saying that your appointments are cancelled. We say that, my lord. High Court expressly said, I won't hear you. And it turned to page 147.
147.
Para 147.
Where do we get that?
Yes, my lord. Para 147, 124, sorry. 124
what?
at page 157.
Internal page?
My lord, internal page, just see para 124, ma'am, of the impugned judgment. We were before your lordships in the first round. Take it from my lord.
165.
165.
Yes.
Now see, plot 1, PDF page. PDF page 205, para 124. In our understanding, all writ petitions relating to recruitment process initiated in 2016. Now, my lord, recruitment process started in 2016, completed in 2018, appointments issued. First writ comes in 2021. Justice Gangopadhyay takes it up and issues notice. That's the foundation of this, my lord, appeal now. Was directed to be heard by division bench, but only those petitions relating to categories as noted above in respect of so-and-so and instituted so-and-so, and appeals arising out of orders passed in such petition. We have understood para 1 of the order of November 9, 2023, that's your lordship's order, to prescribe categories of matters as also time limit for filing writ petition. We have understood order of assignment of the Chief Justice in this context. Now see your lordship's order. Para 10 and 11 of your lordship's order. Plot 9th PDF page, 9th November 2023, my lord. Just see that one.
Para? 9th November order. Acha.
My lord, kindly turn to my lord. Direction. Your lordships have got direction.
Where is that?
What,
PDF page?
A PDF page,
It starts with 157.
157 PDF page. Your lordship's judgment in the first round.
Order of cabinets arrived.
Lord, our SLP was 7172 of 2023 before your lordships.
367.
My lord,
528, right?
yes. Now, my lord, kindly turn to my lord paragraph 10
Lord, there, who was in Noida. He is an accused. He issued the certificate, one individual. That I give you a certificate of 65B4. He is an accused in 464. That certificate is relied upon by the High Court to throw out everybody that obviously what is recovered from him, that hardness is gospel, and all you chaps, my lord, have manipulated OMR. There's several questions which arise.
In fact, there is no challenge to our appointment. They have participated. Writ petition doesn't contain any prayer to set aside
Correct.
selection. No selected candidate is a party. No selected candidate is a party.
Only waitlisted fellows are
It is
here.
4.5 years. All those points were raised.
And my lord, we are substantive. Our main, my lord, fundamental point. How does the High Court terminate, my lord? If you are a substantive employee, you have to have an inquiry, my lord. That's the basic requirement of 311, that you have to have an inquiry. No inquiry, the High Court terminates because the single judge, my lord, who is just now retired, the single judge, my lord, terminated. The court has no power to terminate, my lord. The court can direct an authority. Look at it. So how does the court become an appointing authority to terminate, my lord, 35,000 people?
Lord, we will show, my lord,
I must say,
My lord, these fellows, my lord, will be out of job. There are 4 people per job, my lord, who are dependent.
And
24,000 for knocked down.
91.
may I have a moment,
This is something, my lord, which requires your lordship consideration.
my lord, may I have a moment, my lord?
But we have all been directed to be taken in
Sir,
custody.
I appear for the commission, my lord.
If there are other petitions,
Yes,
Yes, there are.
the numbers to the court master. So I
yeah, we will give the numbers, my lord.
Taken in custody for
No, 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 there's no such direction.
For that.
I appear for the commission, my lord. Kindly give me a minute. I appear for the commission, my lord. We have to taken out an appeal. We have, my lord, several issues to raise before your lordship, my lord. Yes. We had said that we are in a position to check up who are the tainted persons and who are the untainted persons. Because CBI only identified a few persons as being tainted. On that basis, my lord, the court says incorrectly that it is not possible to segregate. We have made a specific submission that we are prepared to segregate. Your lordship's judgment say that where it is possible.
I find that the CBI report at page 281, that says that they have identified 952 candidates for 9th and 10th
Exactly.
and about 907 for 11th and 12th.
Yes. So therefore, my lord,
CBI investigation.
that is, my lord, 10%, my lord, of a particular category.
That's 10%, my lord. For 900, you threw out 9,000.
So that's a.
Your lordships have said, if you can separate the grade.
Hard blood and details, and you proof that they're all corrupt. Monday.
Lordship has given
There are 3 other issues, my lord, I wish to
1994
highlight.
your lordship judgment in 2001 in Delhi, my lord, South Election Commission. matter.
All
94
illegality.
Krishna Yadav till now. In all such, my lord, where the records are not available, there is no question of ability to segregate any one of them. And therefore your lordship decided. my
But
lord,
the evidence has been
and
accepted
process
through
has been
OMR.
undertaken. And all appointments have been set aside in all those cases.
It's my lord's
My
own
lord,
judgment.
High Court is not empowered to do it. That the High Court, my lord, your lordship in Krishna Yadav said, if the records have disappeared and High Court has raised hand that I can't do anything, your lordship said High Court should have enabled it and should have passed the order.
How can the High Court not go?
My lord, I need to highlight 3 more
The
things.
matters.
It's a huge scam, all the
The
national
matters
ministers,
have been
others in
filed.
custody.
One second, let all other matters which are being filed now or which have already been filed and
Yes.
not on board today, they'll be listed together. We'll keep this on next Monday.
My lord.
We'd just like some order so that, if you can just indicate to us, what are the categories?
Yes.
Because, there's no
4
point.
categories.
So if you can just divide the categories, likewise also on your side, so that we have a clear picture of which are those categories in which these different cases fall.
That's right.
But the OMR sheet
Lord, don't-
disappeared, no
That we
record.
have seen, that.
Lord, only one-
Get the judgment.
One problem, 36.1 and 36.3 not wrongly filed. These 2 SLPs cannot be kept on record. My lord, I need
But Mr.
to, my lord,
Mr.
flag
uh,
2 more issues.
Get it this way. OMR sheets are completely missing. The OMR sheets are
They were-
destroyed.
No.
The OMR sheets are destroyed. They say
Not
it's
under
not
the-
even in the mirror server.
Court has accepted, my lord.
You'll have to demonstrate that
Under
that finding is
section
incorrect.
65.
Not with great respect, under the rules, the OMR of 2016.
Jobs are
has been
sold in
written
the
in the-
market. What are
The
the
rules provide
So how long do the OMR sheets?
1 year, 1 year or 2 years. We are now 8 years down. How can you keep a record? Nobody
That's the
can keep
physical
record
copy,
of
not the mirror
50,000
copy.
people, not required.
All right, but Mr. Rodgi, consider this. If OMR sheets are now not
It's
available
not, yes.
for whatever reason.
Yes.
How do you separate the
Yes.
valid from the invalid?
They went,
There is,
Let them produce the OMR sheet before the.
Lord, there are secondary material available.
Oh.
of this evidence has been gone into by the court and the court says it is admissible.
Yes.
Under 65B.
That
We are
is-
of course challenging that,
I've-
but if that is so, my lord, it can be verified. The CBI has used that material.
The SSC has
But
accepted
we
that.
say the certificate issued by an accused.
All of you demonstrate to the court that it is possible to say, in all these matters, question is whether you can segregate. I dealt with the Delhi matter, Mr. Dewan.
Yes.
Correct, we are aware.
We said that it's not possible to segregate in that case. You have Kellon's case, you know, they have cases on both sides.
Correct,
Both
correct.
sides.
You have to demonstrate that, well, on the basis of material which is
separable.
available, it is
Yes.
possible to segregate.
Yes,
do
let them
that.
show.
Those, because we quite see.
Let them show.
Terminate 25,000 people is of a very high order. Unless you are left with a situation where the entirety of the process is wrought with fraud.
But there is
You
no.
show us that, you know, there is material to indicate as to who are the beneficiaries
Yes.
of fraud and those people whose appointments are clearly not,
Para 240, they prepare, well, so commission gives the table that these are identified, these are not complete, and we can't tell you how many more. That the commission admission.
No,
As
Mr.
they are happily
at the end of
It is
it,
an incorrect statement. We said we can.
we will have to hear the matter. It's not a matter which we can just, you know,
That's
T20 matter.
And it takes up plus on Monday, we shall clarify.
8 and 9.
We want some factual clarity.
Yes, sir.
Because when the matter opens, please make sure that, you know, whoever argues in an order. So there should be some element of clarity because the High Court may have had it. They have seen the matter expound before themselves. We don't have it. But we'll look at it threadbare.
straight. Absolutely, we are grateful.
Direction,
One thing, the
Right.
36.1,
direction 8
they are
and
not-
9 should be stayed.
It's a wrong SLP file, my lord. The read petitioners who has not had there. It is completely different petition. Let them correct it.
All right.
Because
36.
direction 8 and 9 should be stayed, Lord, that's,
Nine have to stay.
What is happening between?
You know, let them.
Lord, this is election
No,
time
no,
and the
no,
cabinet.
but I tell you, Lordship, what will
What
happen
is the
is
date of the judgment?
the 22nd April. Now, my lord, I tell
We
you.
have come in
Lordship,
the-
And we are right in the midst of election.
Officers will be there, some on election duty, otherwise they'll be picked up right from the bottom till the top. Whoever was involved with the preparation of the cabinet note, whoever the CBI wants to take and pick up for custodial interrogation.
Even the cabinet, Lord, the cabinet has passed the order.
Lord, we are on election duty.
Preparing for
Lord,
the,
I am only for 39. I am waiting for your lordships to rise.
Oh, you're not in this.
I am
matter?
not in this matter, my lord,
But now,
39.
Mr.
I have
Mr.
conveyed to Mr.
Mr.
Lord, I have conveyed to matter, Lord,
Mr.
Mr.
Raju, are you
Bhushan.
prepared?
I'm in 38,
Eh,
but
eh.
my court said, give me.
Arre, एक minute. Raju, Raju.
Oh, you're not in this matter?
No, it was
Then-
11,000 small persons who have been duped, but I'm in that matter.
Yes, okay.
My lord,
Now,
I
just
have
once again,
conveyed to
who-
Mr. Bhushan, my lord, I have conveyed that the honorable court may take a call on my request. If he's here, my lord,
We'll allow you to take copies of the report, Mr. Bhushan, and the report of the Secretary of the District Legal Services Committee, District Legal Services Authority, Kachar, has been received. The registry shall supply copies to Mr. Prashant Bhushan, learned counsel for the petitioner, and the advocate instructing Mr. Tushar Mehta, learned solicitor general. We'll list it next Monday.
Monday, my lord,
We'll
please.
take it up next Monday.
I have a
Please allow.
request, item number.
Lordships,
Mr. Raju, your matter,
Yes,
we'll take it up, we take it on this week or you want to take it up next week? You are supposed to give us a short.
Tomorrow is in, I've got.
Just
note.
hand over the note to the court master.
I'll-
We'll take it
I'll-
up next Monday.
But in this matter also, my lord, CBI should be represented because CBI report.
You're preparing for CBI in this matter.
In this matter, my lord, Mr. Raju had appeared on.
You're not, it's not that much, it's a.
No.
Are you appearing,
Scam
Mr.
matter, you had
Raju, or
appeared.
anybody?
Lord,
wants
if we will appear, my lord, we are, today we are not here for that matter. We don't have papers.
to- Then you can.
But if they can give, my lord.
Yes, we let someone
Copy
appear.
of
That's
the
very
petition
important.
to Mr. Raju or to the Solicitor General.
Manoj, I'm told we have served. Mr. Bhushan has been
Give
served.
an additional copy.
Very well, Manoj. But in the meantime, no precipitative steps in terms of full signature.
Lord, we are also asking for stay. We are on election duty. Where are we to
No,
go
that
now?
nothing is going to be affected, Lord.
I'm sorry, we can't go home.
1 second.
Our employment stands terminated as of today. Lord.
Where are we to
As per
go?
the judgment.
Terminated.
The Lordship will grant an order of status quo.
The whole.
Then
Any officer of the government who is involved with the cabinet note can be picked up today as per this direction.
Status quo means of your service. Get status quo. Don't talk about that.
Every
But
officer.
any stay would
involved
amount
in
to
the
because
preparation
people
of
are
the
sanctioned to
cabinet
the
note
corrupt
and
appointments.
the supernumerary posts can today be arrested for custodial interrogation if direction 8 and 9 are to be implemented.
High Court said
The apprehension of arrest will be taken care of.
repeatedly.
but nothing else.
I could not them into custodial.
And this is when a single,
CBI
this
investigation
is when a
according to
single
CBI
judge,
is
of the same-
complete.
single judge of the same High Court has stayed the cabinet note, an issue which is not argued, not before the division bench. You direct every.
Lord, I am-
But the judgment.
Lord, I am
is-
making a request for 24,000 people. I
What
am
we do is, what we.
requesting for a stay of termination.
Small Roman 8
Yes.
And
of
9.
para 363.
My lord, your lordships are going to have it on Monday, my lord. It will be.
But
it
eight,
will be-
7, 8, 9.
8 says CBI will undertake further investigations with regard to
Yes,
the.
8
person
and 9 is
involved.
sufficient. 7 is
8,
good.
insofar as 7 is concerned, we are not staying 7.
Yes.
But
8
8,
and 9.
CBI will undertake further investigation with regard to the persons
Statement.
involved in the state government, approving creation of supernumerary posts to accommodate illegal appointments. If
Only 8
necessary.
is enough.
No, so 8 is.
CBI will only stay 8 at
Yes,
least.
yes, and the High-
Lord, what about 2? Our termination of 24,000 people.
Nothing more than that.
But I've been serving for 8 years.
But I am not here for that, but I am not aware of.
List on Monday, till next Monday ka date dal do. No precipitate step shall be taken in pursuance of the directions contained in small Roman 8
Yes.
of paragraph 363.
Para
of the ensuing
363.
judgment of the order of the.
Lord, kindly consider our.
We'll see that after we hear everybody, but today we are just passing an order.
26,000 people should not be terminated.
Oh, they are all everything.
Mr. Singh, we are seized with the matter. We are keeping it next Monday. The other petitions which have come in, today we didn't want something CBI to precipitate any steps under clause 8. We have protected that, that's all.
We are grateful ones.
But these are all illegal appointees without any.
To take care.
Yes, sir.
Can I,
May I
can I take your lordship to you, my lord?
Very grateful. my lord.
My lords, may I have my lord's indulgence?
Just 1 second, we have 37, we have to take up 37, which is a fresh matter.
But
Item 37 is a matter
I'm
where
not yet, no.
a 15-kilometer tunnel is to be dug